Commission. And so it's certainly a pleasure to see everybody back here today. And I look forward to hearing from everybody. I welcome everyone to this oral argument in formal case number 1169 in the matter of the application of Washington Gas Light Company for authority to increase existing rates and charges for gas service. My name is Emil C. Thompson, Chairman of the Public Service Commission of the District of Columbia. Also with me today is Commissioner Richard Beverly and Commissioner Ted Trabue. This oral argument is being held pursuant to the directives provided in orders number 21885 and 21891. Before we begin today, just a few housekeeping matters. This oral argument is being live streamed on the Commission's website. We would request that all cell phones be turned off so there won't be any distractions. If there is some discussion regarding confidential information, the parties need to advise the bench when they propose to discuss such information so that I can ensure that only persons who have signed the appropriate agreement regarding confidential information can remain in the hearing room during the discussion of such confidential information. If confidential information is being discussed, we will disconnect our live stream and turn off cameras until the discussion of the confidential information is completed. We will then continue with the live streaming. I would now like to have each party identify themselves and their representative who will be speaking today. First, we'll start with Washington Gas Light, and then the People's Counsel, and then the interveners in alphabetical order. I understand that there are certainly some parties here that will not be speaking, but if you could still just introduce yourselves for the record, we would certainly appreciate that. We will then also use the same order during oral arguments as parties present their arguments. So first beginning with Washington Gas Light. Yes. Pleasure.
Good morning, Your Honors. I'm Fran Francis, Senior Vice President and General Counsel of the Apartment and Office Building Association. I will be presenting the oral argument today.
Good morning.
Good morning, Commissioners. Lauren Cullum, Special Assistant Attorney General, speaking on behalf of the District of Columbia Government through the Office of the Attorney General.
Thank you.
Good morning. Michael Engelman, outside counsel for DC Water. We will not be making an oral argument today.
Thank you.
Christy Singleton, Senior Assistant General Counsel for GSA. We will also not be doing an oral argument today.
Good morning. Tim Oberleiten from Earth Justice representing Sierra Club. With me today is Sarah Amiel from Sierra Club.
Thank you.
Sorry, my colleague Kelly Burnell is here with me as well. I apologize for introducing you before.
Happy to have you. Before we begin, just a little background on formal case 1169. On April 4th, 2022, Washington Gas Light Company filed an application requesting authority to increase existing rates and charges for natural gas service in the District of Columbia. The requested rates are designed, if fully granted, to collect approximately $226.4 million in total annual revenues, which represents an increase in the company's weather-normalized annual revenues of no more than $53 million, including a transfer of $5.3 million associated with costs from the natural gas system upgrades currently paid by customers through the Project Pipes monthly surcharge, resulting in a net increase of $47.7 million in new revenues. The new revenues reflect an overall increase of approximately 20.4% over and above current bills. The company also proposes the climate progress adjustment in its proposed rate structure that the company alleges will benefit customers and the company. According to WGL, the proposed CPA stabilizes customers' annual bills for the delivery of energy while also allowing WGL the opportunity to recover its approved revenue requirement, notwithstanding reduced customer consumption in direct alignment with the district's climate goals. The company is also proposing a Climate Action Recovery Tariff, a CART, a regulatory mechanism to allow the company to timely recover costs associated with the company's efforts to support the district's climate goals. In order number 21885, the Commission determined that instead of the traditional evidentiary hearing in this proceeding, the Commission would permit parties to present oral arguments about issues that they believe are fundamental to the resolution of the issues in this proceeding. The Commission determined that each party would have 30 minutes for oral arguments, proceeding in the following order: WGL, OPC, and the other parties in alphabetical order. WGL could reserve no more than 10 minutes of its 30-minute presentation to respond to other parties at the conclusion of the oral arguments. The Commission also indicated that commissioners may ask the parties questions during the oral arguments. We are now ready to proceed with oral arguments, but before we begin, I just want to make sure, are there any preliminary matters? Okay. And any other additional questions in terms of process or procedure? Okay. We'll start first with WGL. Please head towards the podium, and then if you could, when you begin, just announce your name once again.
Good morning. Again, my name is Kathy Thurston Signius, and I'm representing Washington Gas Light Company in this proceeding. Washington Gas appreciates the opportunity to address the Commission regarding the fundamental issues that will be decided in this case. I would like to reserve 10 minutes of my time for rebuttal. The fundamental issues I address this morning are critical to our customers who continue to rely on natural gas as an important component of their energy mix and will continue that reliance for many years. A financially healthy utility working in tandem with the Commission and customers is essential to providing safe and reliable utility service in both the near term and in the future. The rate relief the company seeks is necessary to achieve that goal. Washington Gas's recommendations in this case provided the resources it needs to meet its current obligations and progress towards future objectives. Washington Gas has been operating in the District of Columbia for 175 years, providing safe and reliable energy for heating, cooking, hot water, and other uses, the basics of life that we all need, to over 165,000 customers in the District of Columbia. Of course, the energy landscape in the district will continue to evolve between now and 2050. However, our customers and our stakeholders in the district are depending on us now to continue to deliver safe and reliable natural gas service. Whatever the future may hold, as long as the company is responsible for meeting its statutory obligation as an energy provider, it must and it will continue to invest in the upkeep and enhancement of its system. That requires Washington Gas to be a financially strong utility that customers can rely on for their energy needs today, tomorrow, and for years to come, with an opportunity to earn a fair return on its investments. Washington Gas recognizes and appreciates the focus on our climate and the need to reduce greenhouse gas emissions. The company joins in the effort and needs fair rate-making treatment to do so. Of course, the climate challenge will not be resolved overnight. It will take multiple participants working together to come up with multiple approaches to address it. Discovering the approaches that work, refining them, and then scaling them to ensure they contribute to reducing GHG emissions should be the goal of this commission. That is why the company seeks adoption of certain proposals, including the Climate Progress Adjustment and the Climate Action Recovery Tariff, or CART. These mechanisms align with DC's climate goals and will move the district in that direction. Importantly, we must also acknowledge the impact decarbonization initiatives will have on Washington Gas's financial posture, as reduced greenhouse gas emissions will result in reduced revenues for Washington Gas. Implementing energy efficiency programs will reduce gas usage, as well as revenues that the company needs to continue the provision of safe and reliable service. The Climate Progress Adjustment and the CART address that impact because they equip and incentivize Washington Gas to help drive energy efficiency and reduce greenhouse gas emissions. Washington Gas filed its base rate application on April 4th, 2022, seeking an annual revenue increase of $53 million, of which $55.3 million represents the revenue requirement of costs currently being collected through the Project Pipe surcharge that the company seeks to transfer into base rates. Through the company's pre-filed testimony, we have shown that Washington Gas's base rates are insufficient to meet its cost of providing service in the District of Columbia. No other party has established that this fact is in dispute. Washington Gas has also demonstrated that its existing rates do not provide the company with an opportunity to earn a reasonable rate of return in the district. No other party has established that this fact is in dispute. The company has shown that it is operating at negative cash flows and is severely under-earning. Based on an unadjusted test year and actual weather, current rates generated a rate of return on rate base of 3.69% and a return on equity, or ROE, of 3.31% versus the authorized ROE of 9.25%. No other party has established that these facts are in dispute. There are a number of factors contributing to Washington Gas's need for rate relief, including growth in rate base that is needed to provide safe and reliable service to customers, inflationary pressures causing increases in the cost of providing service, and I'll briefly mention this again regarding ROE, requirements imposed by DC government related to construction activities such as permitting, paving, restoration, worksite setup, and restricted working hours, all of which increase the cost of operating in the district, and employee-related expenses, such as known and measurable labor costs that the company will, at a minimum, incur in the rate effective period. The company urges the Commission to remedy the inadequacy of existing rates by granting Washington Gas's revenue request to ensure the continued provision of safe, secure, reliable, and vital energy to district residents and businesses by a financially sound and well-resourced natural gas utility. The Commission should approve the company's proposed climate progress adjustment for two reasons. First, the climate progress adjustment will address the impact of variations in weather patterns and reductions in gas usage from energy efficiency and other conservation measures, all factors outside of Washington Gas's control. At present, the majority of Washington Gas's distribution revenues are collected through volumetric charges, but under Washington Gas's current rate structure, 99% of the company's non-gas costs are fixed. Only 18.5% of the company's distribution revenues are collected through fixed charges. The climate progress adjustment will address this imbalance by better aligning the collection of revenues with how the company's costs are actually incurred, so that the recovery of fixed costs is not dependent on the volume of gas consumed. Second, the climate progress adjustment creates an incentive for the company to further promote energy efficiency. Washington Gas has proposed a suite of energy efficiency programs in formal case number 1160 and expects to administer energy efficiency programs in the District of Columbia during the rate effective period. These programs are designed to reduce gas usage in the district. At the same time, they will reduce the associated revenues that would otherwise be collected through base rates. In fact, as the Commission has long recognized, decoupling mechanisms like the climate progress adjustment are generally offered as a means to accomplish public policy goals of promoting energy efficiency and making a utility indifferent with respect to the reduction of energy consumption. In this proceeding, Washington Gas addressed all of the concerns the Commission raised regarding the company's prior revenue decoupling proposal in formal case 1137 and has demonstrated a decline in usage per customer, the financial pressure experienced by the company in the absence of a decoupling mechanism, the proposed plus or minus 10% cap on volumetric distribution charges helps to mitigate volatility in month-to-month customer bills. And even with the climate progress adjustment, a customer who reduces gas consumption will see gas reduction in their charges. The climate progress adjustment will allow Washington Gas to help further the district's decarbonization goals through the promotion of energy efficiency measures that will reduce gas usage and thereby reduce GHG emissions without negatively impacting its revenues. As explained in testimony, without a revenue decoupling mechanism, the company is rewarded with higher revenues when it is colder than normal, or, for example, customers choose not to replace inefficient furnaces, whereas the company is penalized with lower revenues because it is warmer than normal or customers engage in conservation activities. With the climate progress adjustment, customers benefit through the credit on their bills when temperatures are colder than normal. And as I said, to mitigate volatility in customer bills, Washington Gas proposed the monthly cap on customers' volumetric charges. The climate progress adjustment would also mitigate the impact of large swings in weather patterns, offering more stability in customer bills under those circumstances. In fact, many states have adopted some form of non-volumetric rate design to better align utility costs with revenues, with only 12 states without any mechanism to remove the disincentive for local distribution companies to pursue decarbonization and energy efficiency measures. Revenue decoupling mechanisms have been widely adopted in the United States, including in the other jurisdictions in which Washington Gas operates, as well as this commission, with 24 states adopting such mechanisms for local distribution companies they regulate. Decoupling mechanisms have been operated successfully in Maryland and Virginia for over a decade. If the climate progress adjustment is adopted, the Commission should not reduce the company's ROE because the allowed return should be commensurate with the returns expected elsewhere in the market for investments of equivalent risk. Given that all the companies in Washington Gas's proxy group have decoupling mechanisms, any reduction in risk from the approval of a decoupling mechanism is already reflected in the market data of the proxy group. For all these reasons, the Commission should adopt the climate progress adjustment for Washington Gas. Washington Gas is proposing several forward-looking adjustments and changes in rate-making policy to ensure the test year more accurately reflects the costs and conditions expected in the rate-effective period. If the Commission sets rates based on the 2021 cost structure and investments during that year without approving proposed forward-looking adjustments and alternative rate-making policy changes, the company will not have a reasonable opportunity to recover its costs or an opportunity to recover a return on its investments. The company has proposed forward-looking adjustments that are synchronized to reflect both costs and revenues expected when rates go into effect. In this case, the projected rate effective period, the 12 months ended March 31st, 2024, will end very shortly after the expected issuance of a final decision, which highlights the need for adoption of forward-looking adjustments to afford the company a sound financial position to continue the provision of safe and reliable service to its customers. Among these proposed adjustments is the inclusion of construction work in progress, or CWIP, in rate base. Washington Gas seeks inclusion of CWIP in rate base to recognize the company's growing amount of construction activity in the district due, in part, to accelerated pipe replacement activity not recovered through project pipes, and pipe replacement activity associated with DC plug. The Commission allows recovery of CWIP financing costs in the project pipe surcharge, yet the company is denied recovery of financing costs of CWIP in base rate proceedings. By including CWIP in rate base, Washington Gas will have an opportunity to earn a return on its investments and recover its financing costs for CWIP, as it does in the other jurisdictions in which it operates and as is afforded the company under the Project Pipes program. Washington Gas presented a normal weather study in this proceeding to determine what constitutes normal weather for purposes of determining rate-making revenues, given that volumetric rates are set based on a normalized level of gas usage. Weather normalization analyses were conducted to estimate weather-sensitive gas use in the rate-effective period under normal weather conditions. The company prepared the best estimate of normal weather usage using the most recent 30 years of weather data from the National Oceanic and Atmospheric Administration, or NOAA, and statistically valid regression analyses in the estimation process. The company is the only party that has prepared a reasonable and rational estimate for normal weather. Washington Gas presented testimony that the 10-year and the 30-year averages for estimating normal weather proposed by the other parties are not very accurate or generally accepted as a standard in light of the warming trends in recent years. The company further highlighted that NOAA scientists cautioned against blind implementation of using 30-year averages to estimate normal weather. The company's normal weather presentation meets the requirements directed by the Commission in Order Number 17132 and is the most reasonable and accurate normal weather proposal in this case. Therefore, the Commission should approve it. The company is proposing a labor inflation adjustment to address the effects of inflation on the company's cost of providing service in the district. Consistent with the non-labor inflation adjustment the Commission approved in formal case number 1156, the company's proposed adjustment is based on inflation forecasts published by the Philadelphia Federal Reserve. It is undisputed that inflation has an impact on the cost of providing service. the commission should approve the company's proposed non-labor inflation adjustment.
Ms. Signew, I hate to interrupt you, but I do want to ask you a few questions before your initial time is up. I want to first go back to the climate progress adjustment that you talked about that Washington Gas is proposing. How is this proposal different from what was proposed in 1137, formal case number 1137, and why should it be approved this time?
It is a similar decoupling mechanism. The company has addressed the concerns that the commission raised in formal case 1137, so that, we will be able to satisfy all of the commission's requirements with regard to the CPA.
Okay. One of the things that you said there were two reasons why the CPA should be approved. One dealt with the variations in weather that led to decreased heating days, and then also further incentivize Washington Gas Light to promote EE programs. As of now, there's only there's a proposal before the commission for EE programs, but none actually in use by Washington Gas. So would the decoupling mechanism be putting the cart before the horse in that manner?
We don't think so. As you said, the company has proposed a suite of energy efficiency programs, and the commission is moving forward in that docket, and we would expect those programs to be implemented, if they're approved, within the rate effective period. So we think it's not premature.
Sorry to interrupt you. Please continue.
Can I ask a follow-up too? Commissioner Beverly, go ahead.
I just wanted you to state, for the record, what would happen if Project Pipes were discontinued?
Honestly, I don't think I can respond to that. We're certainly happy to provide a response to a bench request. Obviously, the company is going to maintain its system and continue to make it safe. But in terms of accelerated pipe replacement, I don't think that I can answer that question for you.
Also, in terms of reliability and safety, that was the reason that we did Project Pipes, right? So I was just trying to get an idea of what you think the ramifications would be if the commission discontinued that program.
Well, we certainly think that the pipes program enhances the safety of Washington Gas's system, but regardless, the company will continue to abide by all of the federal and state regulations as it relates to pipeline safety.
Okay, are you currently reducing your annual GHG emissions? And if so, by what amount?
Yes, the company is engaged in Project Pipes, and that is reducing GHG emissions. And the company does file an annual report in formal case 1162 regarding its GHG emission reductions.
Would those reductions go up based on the CART? So if the CART is approved, your reduction would increase, but by how much? Do you know that?
I don't know that we've calculated that in the testimony, but certainly it will decrease emissions because the programs that we proposed, are designed to do that.
I haven't seen anywhere where, maybe I missed it. What is the total greenhouse gas emissions for Washington Gas's system? Do you have that figure somewhere? Because when we talk about reductions, I don't know what it's reduced from.
I don't have that, but we're happy to provide that in response to a bench request.
Okay, just so I can be clear, what I've heard in the past, I could be wrong, is that it's 6,000 metric tons over 3 years, but I don't know what that's 6,000 out of. I don't know what that's 6,000 out of 60,000, 600,000, 6 million. So if I could get that information, that would be helpful. My final question is with regard to a commitment the company made in the merger. In the merger, the company committed to developing or causing to be developed 10 megawatts of capacity from renewable energy resources. So far, that hasn't been done. The time for performance has passed. So my question is, why should you get a rate increase when the company hasn't fulfilled that commitment?
So, not to split hairs here, but this is an AltaGas merger commitment, number one. Washington Gas had made, AltaGas has made some progress, as you're aware, and then 10 megawatt requirement. We're negotiating, or we'll begin negotiating with the district government on how we can continue to try to meet that commitment. So at this time, I can't tell you what the company's plans are, but we're certainly negotiating with the DC government to try to make sure that that commitment is fulfilled.
Well, the fact that you're negotiating it is helpful, encouraging. So thank you for that.
Yes.
But
Thank you. Good morning.
Morning.
I think in your your statement, you mentioned that Washington Gas has sought, regarding the climate progress adjustment, a similar regulatory structure in other states in which it operates. Specifically, I think you have this allowance in Maryland and Virginia. Am I correct?
Yes.
How is the proposal that's in front of us today similar or different from the structures that have been adopted in the bordering jurisdictions?
To my knowledge, they're very similar, particularly with regard to Maryland. I'm not very familiar with the Virginia program, but it is a decoupling mechanism. And if you would like more information on those particular programs, we're certainly happy to provide that.
Sure, I'd be happy to receive it. Thank you. Further, you stated that one of the reasons for that you suggest that we should adopt this measure is because it would help you, I guess, stabilize rates with regard to energy efficiency activities. Are those activities that would solely be conducted by Washington Gas or other activities within the District of Columbia? Let's say that the district government, of course, runs robust energy efficiency and electrification programs, which clearly impact revenues at your company. Would this card compensate you for both of those, or just activities that are conducted by Washington Gas itself?
Well, the CPA would allow Washington Gas to recover the cost that the commission authorizes in any base rate proceeding. So if it's the result of any Washington Gas energy efficiency programs or any other conservation measures, that would all be factored into it.
Okay. Have you, and maybe this is a little bit similar to Commissioner Beverly's question, I think you said you have quantified how much your revenue has been diminished by energy efficiency or electrification programs that have been conducted in the city in the last, 2 to 5 years?
Our witness, Paul Robb, did prepare a quantification of a decline or the financial impact on Washington Gas as part of his testimony.
Okay, all right. Thank you. That's all the questions I have. Mr. Chair.
I believe you requested to leave the final 10 minutes for rebuttal. So at this time, we'll call Office of People's Counsel to the stand. Thank you.
Thank you.
Good morning, and thank you for the opportunity to respond to WGL and to provide our points for the OPC to highlight some of our fundamental issues with WGL's rate application. I'll begin with 4 overarching points to provide context regarding the company's proposals in this case. First, WGL claims that its rate increase is driven by investments to support customer needs and increased costs. But the record demonstrates that despite significant capital expenditures over the past 5 years, WGL's operational performance in terms of leak rates and pipe replacements has been substandard. WGL also failed to meet customer service quality standards for most of 2020 and 2021. This subpar service, which involves failures to meet related merger commitments, warrants downwards adjustments as have been proposed by OPC's witnesses. Second, while WGL claims it is facing financial harm, the record shows WGL's claims are unsupported. As explained by OPC witness Ostrander, WGL's financial statements do not raise the issue of substantial financial harm. its parent Alta Gas's earnings reports for 2022 and 2023 are very positive. WGL has not requested emergency rate relief, and it has not identified in its testimony any formal cost-cutting, efficiency promoting, or force reduction measures that it has to undertake because of its financial concerns.
I just want to ask you a question right there. I mean, does Washington Gas have to show those things in order to warrant a rate increase?
It bears the burden of proof in this case. If it's claiming it has financial harm, it must demonstrate it in a manner, and it also needs to still tie that all of its proposals in this case have been substantiated by the probative evidence. It has not done so. So the claims of financial harms, of course, the commission takes those into consideration, but it also has to take into consider what is in the evidence of this record. Is it substantial to support the claims it is proposing or the proposals that it is making? And so each needs to be taken on an individual basis to make sure that it meets commission precedent, it is substantiated by evidence, and the commission must also bear in mind that it has also a responsibility in considering the consumer interest when it considers what is a just and reasonable rate. So, and we do think that it is important, and that if the company is claiming that it needs certain proposals to address its financial concerns, that it also provides the ratepayer protections that are required with respect to some of those proposals. WGL also claims, and one more thing with respect to the financial concerns, WGL has paid higher amounts of short-term incentives to its employees in 2020 and 2021 than it has in the past 10 years, which also undermine the financial harm concerns. WGL also claims it is under-earning, but this claim is based on WGL's own inflated 10.4% ROE. Long-standing Supreme Court precedent makes clear that utilities are authorized, not guaranteed, a particular rate of return. OPC witnesses have also shown that the company consistently overestimates the amount of incremental revenues it needs by a significant margin. Thus, WGL's claims about its earnings are also without merit. OPC witness Dr. Dismukes actually explains what this proposed rate increase means to low to moderate income households living in the district. And it is important to note that it would mean that it would add an additional $22.5 million in an annual burden to such customers, which equals to approximately 42% of what the company's total proposed revenue increase is in this case. Again, the commission must ensure that the consumer interests are considered when it is determining what is a just and reasonable rate. It is, again, important to note that WGL bears the burden of proof, and this means that WGL has the burden of persuasion to affirmatively convince the commission that the elements of its proposed rate increases are just and reasonable and in the public interest. And when it is seeking to depart from past precedent, the company bears a heavy burden. And third, many of the substantive proposals and procedural claims WGL has made in this case evidence an intent to depart from traditional rate making and to limit traditional rate review. For instance, WGL complains that parties requested extensive discovery and evidentiary hearings, but these are basic and fundamental due process procedures that regulated utilities face throughout the country when they seek rate increases. From a substantive perspective, WGL's CPA and CARD proposals would depart from traditional rate making, but they do not provide the adequate ratepayer protections or benefits to justify such a departure. And while WGL couches them as climate proposals, they have not been demonstrated to meet or advance the district's climate goals. And in fact, since the commission is separately evaluating the energy efficiency programs and the cost-benefit analysis to apply to climate proposals, the approval of the proposals here would be premature and unreasonably shift the risk to ratepayers for costs that may not be consistent with determinations the Commission will make on a preferred pathway to meeting the district's climate goals in formal case 1167. WGL also seeks to vary from traditional rate making and commission precedent in a number of its other proposals. For instance, WGL recognizes that the Commission typically excludes construction work in progress or CWIP from rate base, but it seeks such a forward-looking adjustment. As OPC witness Ostrander has demonstrated, WGL does not meet the three-part standard the Commission applies in permitting CWIP in rate base. 22 of the larger projects that WGL proposes to include in CWIP are behind schedule, creating uncertainty of when the CWIP will actually be included in gas plant in service, or GPIS, and when completion dates of CWIP will be known and measurables. Those are the standards in which the Commission's precedent considers with respect to whether to approve CWIP and rate base. It is not reasonable to allow CWIP and rate base and require customers to pay in advance for plant that is not used and useful and whose costs and in-service dates are not known and measurable. As the Commission has recognized, a utility seeking to depart from existing policies bears a heavy burden of persuasion, and the record here does not support the change. As another example, Commission precedent requires use of the most 30 recent years of independently generated data for weather normalization, and it would be a stretch for WGL to claim that its arch-arch method complies with that precedent, since it is based on a complicated model that uses data that goes back to 1936. WGL concedes that its proposed arch-arch methodology for weather normalization is not commonly used in base rate cases or regulatory proceedings. WGL's weather normalization serves to increase its revenue requirement when compared to OPC's proposed simple weather normalization that is consistent with the Commission's precedent, which, if applied, would reduce the revenue requirement by $5.2 million, approximately. Fourth, WGL points to Maryland, Virginia, or other commissions' rules and processes, such as with respect to their suspension periods, their decoupling mechanisms, and return on equity determinations. But those jurisdictional rules and processes have different statutory requirements, and I will get to that a little bit later. And they also have different factual differences, such as different levels of evidence presented in those commission cases, different ratepayer protections required or provided, and different measured climate benefits, and some of them are resulting from settlements. Reliance on other jurisdictions' distinguishable rules and processes does not allow WGL to overcome its burden of proof in this case, and does not provide substantial support for the Commission to depart from its own statutory obligations and precedent. So for these reasons and more that I will discuss in detail, the Commission should reject the CPA and CARD proposals and make the other adjustments recommended by OPC. I will now provide a little bit more detail on some of these fundamental issues. So with respect to the climate progress adjustment, there are three reasons for rejection. First, WGL has not demonstrated that it meets or advances the district's climate goals. It does not meet the Commission's precedent for approval of decoupling mechanisms, and it does not provide adequate ratepayer protections or benefits. So first, WGL fails to establish by substantial evidence that the CPA is consistent with or will advance the district's climate goals. OPC witness Stanton testified that the CPA benefits the company by reducing its earning volatility and sales risk, but with little demonstration of climate mitigation impact. WGL witness Rob concedes that, quote, nothing in the company's direct case explicitly links or conditions the proposed CPA mechanism to measurable progress toward the achievement of climate goals, end quote. Witness Rob also concedes that the CPA, quote, does not provide incentives for conservation by the company's customers, end quote. Second, the Commission should reject the CPA for the same reasons it rejected WGL's similar decoupling mechanism, the RNA, in FC1137. In that case, the commission cited 4 deficiencies with respect to the RNA, and those same deficiencies are present with respect to the CPA. The first deficiency in FC 1137 was that WGL failed to show that the reductions in natural gas usage in the district were the result of the company's efforts to promote energy efficiency. And as your questions have demonstrated with respect to the energy efficiency programs, WGL has not implemented them, and so it cannot make that fundamental showing.
Sorry, does it have to be Washington Gas's programs only that lead to the reduction?
Pursuant to the commission's precedent in FC 1137, that was an important consideration for the commission. So I would submit that yes, they do need to demonstrate that to allow for them to meet the commission's precedent, or to provide substantial evidence and demonstrate why it would be appropriate for the commission to depart from that evidence, from that precedent. The second FC 1137 deficiency related to a lack of proof that reductions in natural gas have resulted in declining sales, warranting approval of a decoupling mechanism, or that WGL is incurring financial pressures due to the lack of a decoupling mechanism.
I'm sorry if I could interrupt for a second. I understand the company's argument with regard to the decoupling mechanism necessary to stabilize the company's revenues. I heard you say, and I just wanted you to expound a little bit if you can, on whether or not the decoupling mechanism incentivizes energy efficiency. I think I heard you say, your witness said it did not. So if you can...
A decoupling mechanism on its own does not incentivize energy efficiency if the energy efficiency measures are not being undertaken by the company. There needs to be a link to that. A decoupling mechanism is reducing risk from the company. In return, it needs to show that it's providing the benefits it claims that are warranted to depart from that traditional rate-making mechanism that does not allow for the decoupled nature between sales and revenues.
Let me phrase it another way. What's the impact of the decoupling mechanism on a customer bill? So if I'm a customer, I'm faced with a decoupling mechanism, I engage in energy efficiency, does my bill go down or does it stay the same?
Well, what the record shows is that an individual customer will not be able to tell whether what it has done to reduce its own energy usage will be, related to its reductions in bills, because WGL's proposal, it considers the entire customer class. It's not whether an individual user, it's not linked to a specific meter. It is a customer class-based adjustment. So an individual customer will not know whether it's done what it needs to do in order to, get a lower rate or a lower bill. And in fact, what's going to happen is that the company claims, well, we have a 10% cap, but there is going to be volatility in month-to-month variations, which was another FC 1137 deficiency that the commission identified, and it still exists today. And the 10% in the company's proposal, and the 10% cap will still lead to rate shock, excessive rate volatility, and importantly, the 10% cap doesn't mean they will not recover the rest of it. They still propose to defer that for future recovery. So you will have customers that may end up having volatility, month-to-month variations, subject to that 10% cap, but again, subject to further future requests for recovery. And so the other part of the FC 1137 deficiency was with respect to, as I mentioned before, financial pressures. But OPC witness Dismuke's analysis demonstrates that WGL has not experienced declining sales due to any reductions in natural gas usage, nor has the company experienced financial pressure due to the lack of a decoupling mechanism. Instead, his analysis demonstrates that the company has seen growth in its revenue per customer and growth from new customers added to its system. So WGL has failed to demonstrate with substantial evidence that its CPA proposal should be approved. I'll next turn to the CART proposal.
Before you turn to that, let me ask one or two other questions about
Sure.
the CPA. I think you mentioned that a customer would not understand whether or not, or that their bill is lower after engaging in energy efficiency programs? Is that what your statement is?
Well, there is no energy efficiency program by the company to give me a record evidence to cite to, but what Dr. Dismukes explains in his testimony is that this is, the adjustment is based on the entire customer class. And that was what the commission in FC 1137 said is insufficient to, is another deficiency with respect to their decoupling mechanism.
So a customer engaging in energy efficiency programs would realize lower rates on a lower bill. Let's say if they put in a more efficient
I don't
furnace in
believe
their
the
home.
record has anything that I can cite to answer that question. I could review and confirm, but my understanding is that there has not been a demonstration made that any energy efficiency program will result in any individual customer's use warranting the approval of the CPA. The record does not have that because, again, this proposal is premature. When the commission considers those energy efficiency programs in the other docket and determines whether to approve them, and then the company comes back, and to the extent that it's consistent for it to come back with the commission's decisions in those cases, it can be addressed then.
So you're saying this is a cart before the horse argument?
Very much
So
so.
let's say that you reverse that and let's potentially down the road, we approve some energy efficiency programs that Washington Gas would operate. It is at that point that you think that the examination of something like a CPA would be appropriate?
Yes, to the extent it also meets with the other commission determinations, including what the pathway to climate progress is in this
Assuming those
district
programs
and
are
so
aligned
forth.
with the city's
Yes.
climate goals, yes.
Yes, this is a premature proposal,
All right, thank you.
as is the CART, which I will turn to next. And there's 3 reasons to reject the CART proposal, beyond the fact that it's premature. The company has not sufficiently demonstrated that the CART programs will advance the climate goals of the district. OPC witness Stanton testified that the CART programs are insufficient to meet the district's climate goals. WGL also does not provide information in its application on the anticipated GHG emission reductions from its climate goals, so your questions were appropriate to see if there is any demonstration in the record, and there isn't. The company states it will provide additional information to the commission while the programs are implemented, which shows it is premature to approve it now. Second, the company has not sufficiently demonstrated that the CART programs justify special cost recovery treatment through the CART mechanism, as opposed to the traditional cost recovery mechanisms. Trackers and surcharges like the CART mechanism are disfavored, and the commission has traditionally evaluated such mechanisms based on 3 criteria. OPC witness Dr. Dismuke's testimony demonstrate that WGL does not meet the traditional CART criteria because the CART program costs are not large compared to WGL's overall cost structure. The cost will not be beyond WGL's control, as WGL proposes to have a project team dedicated to managing the CART programs, and the CART programs costs are not volatile in nature. Those are the standards, and the record does not support granting that non-traditional mechanism. And the company does not adhere to the commission precedent and instead establishes its own criteria for approving trackers and surcharges, and those are explained in Dr. Dismuke's rebuttal testimony. WGL has not conducted any studies or benefit cost analyses demonstrating that the CART mechanism is the most efficient tool to address a reduction in GHGs. And the company has failed to sufficiently demonstrate that the CART mechanism will protect ratepayers. The CART mechanism disincentivizes cost containment undermines the positive effects of regulatory lag, and results in less information sharing, oversight by the Commission, and participation by stakeholders. WGL does not identify any ratepayer benefits that will result from the CART mechanism other than allowing WGL to recover costs in a timelier manner. I will also refer you to the Commission, to the Dr. Dismuke's testimony and Stanton's testimony on what measures the Commission should take if, and we do not recommend the Commission approve the CART, but there are certain conditions that the Commission must consider if it does intend to do so. I'll now turn to the forward-looking adjustments that WGL is proposing. The company acknowledges that the Commission has only allowed limited forward-looking adjustments, but the company claims that this departure from traditional rate-making and precedent is warranted with respect to its 5 forward-looking adjustment for 2 reasons. 1, because the rate year it proposed in this case will end very shortly, and 2, its financial health claims. I've already explained why the financial health claims are unsupported, and I'll briefly explain additional reasons warranting the rejection of the forward-looking adjustments.
I'm sorry, I would like to move you to a different part because I think we have about 5 minutes left.
Sure.
You mentioned it in your openings, your initial discussion about the reduction in ROE due to substandard performance. I want to turn to that and just focus on that a little bit more.
Sure. So the Commission has precedent providing that if there's disappointing service, safety, and reliability, it can reduce the ROE. That site is in witness O'Donnell's testimony, and the reasons are all explained in OPC witness Walker's testimony. Some of the testimony relates to Project Pipe's confidential issues I will not get into, but the record demonstrates that WGL's hazardous leak rates have increased, its pipe replacement has been slow, and there are many other operational deficiencies identified in OPC witness Walker's testimony that justify this, including its failure to even meet its merger commitment with respect to one of its grade leak reporting requirements, and it has paid those penalties. But the 5 years of the merger conditions are almost up, and even the penalties have not prompted WGL to improve on its leaks. And so that is another reason that warrants the 25 basis point adjustment to the ROE.
If the system is old and needs replacement, and that's the cause of at least some of these leaks, how do you, I'm trying to figure out the best way to kind of, it's some ways a circular argument in my head. If the system is old and has leaks, and then you have an accelerated pipe replacement program to try and address these leaks, and then you've already fined the company for these leaks, and I think there's been a recommendation here to not include some of the Project Pipes money into the rate base. Just kind of just explain to me that thought process there, because it's...
Well, I will explain that the penalties only relate to the modest 2% per year grade 2 leak reduction target in the merger commitment. So it's not being, the penalties are something it committed to for that specific issue. The other reasons for some of the Project Pipes may be related to the issues that witness Ostrander talks about for different reasons. The lack of known and measurable in-service dates and costs. And so if it's not known and measurable, it cannot be included in the rate base. The other issues with respect to safety and reliability, WGL has been given this accelerated recovery process, and WGL has not performed properly. The OPC witness Walker's testimony goes in detail with respect to all the deficiencies with respect to how it is, replacing aged pipes, And also, we need to bear in mind the future of WGL and the Commission's considerations in other dockets that impact the reasonableness of its proposals here. But taking it on its own, the service quality that the company is supposed to provide to customers should be safe, reliable, and affordable. And hazardous leaks rates that are increasing, it's failure to do what its peer utilities are doing. And OPC Walker talks about what the peer utilities in the country or in the East Coast are doing. And the record demonstrates that, it's not measuring up. So a utility should be able to timely address its replacement program, and it has not done so. I will also address the cost of capital. It's plainly excessive. It's beyond, even though it cites to Maryland and Virginia, and those are also based on, one is based on a settlement, but it's still far in excess of what is even approved in those commissions. And in its limited brief, WGL focuses on current capital market conditions and cites to current interest rates as warranting higher ROEs. In this regard, the company claims that the last time the Treasury yields were over 4% in 2020 and 2011, authorized ROEs for gas companies averaged 9.9 with a median of 10.10%. But interest rates are only one part of the picture. And I call out to the fact that OPC witness Rothschild has explained that the data indicates that the cost of equity for utility companies has been trending down in 2023, along with investors' volatility expectations. Volatility expectations should be taken into account. And in fact, WGL's witness DeAscendis's rebuttal testimony also discusses many other capital market factors that should be considered, including stock market volatility and historical and investors' expectations. So pointing to one issue, the interest rate levels, is not sufficient to warrant the 10.4% inflated ROE that is based on flawed models, as explained in OPC witness Rothschild and O'Donnell's testimonies.
Do you have a comparison of current ROE cases for gas utilities that have settled within the last year, or settled or disputed cases?
I'm not sure offhand. I can look at that and provide that as a bench request if it is in the record.
Thank you.
Just had a question. Do you think performance-based rate making would be a better approach to some of these issues with regard to Washington Gas's performance? I have a concern that I think was maybe the chair's question as well. How do we get to better performance by finding the company and reducing their rate of return and doing things that may in fact actually impede the company from being able to do the work you're trying to get them to do? At some point, if you beat the horse too much, you drop the horse. You don't get better performance.
Those are interesting questions, Commissioner. However, the record here does not allow me to respond to that question. What WGL has proposed here is a historical test year. It is claiming that it needs certain incentives. However, your question is a broader one, and unfortunately, because I am limited to what is in the record, I cannot opine on it.
That's fine. I'm throwing that out there for general consideration. I understand that you would not come prepared to answer that question, but in my mind, I think that's where this discussion is ultimately headed, that we need more of a performance-based rate-making system rather than a penalty-based system trying to get performance. But that's just my thought, and I'm throwing that out there. So I appreciate your response.
Thank you.
Understand that you are out of time. Commissioner Traby, do you have any additional questions you want to ask?
I'm fine, Mr. Chairman.
Okay.
Thank you.
Thank you. And I failed to say this at the beginning. Sorry, please take the stand. At the beginning of the People's Counsel witness, but please just state your name again for the record.
Good morning, Chairman Thompson, Commissioner Beverly, Commissioner Ted Trabue.
Good morning.
I'm Fran Francis, appearing on behalf of the Apartment and Office Building Association. I believe this is the first time I've appeared before Chairman Thompson and Commissioner Trabue, and I don't believe I've seen Commissioner Beverly in person in a couple of years. Good morning. I'm glad to be here, seeing everyone in person.
Thank you.
To start, I would like to establish some general background for the Commission's consideration. There's a lot of agreement among the non-utility parties in this case, and AOBA, that Washington Gas has not justified its requested increase in rates and proposed surcharges
Fern.
in its application. It cannot be overemphasized that this is the largest rate increase ever requested by Washington Gas in the district. Washington Gas is seeking an increase in weather-normalized annual revenues of $53 million, including a transfer of $5.3 million of cost from the Project Pipes monthly surcharge. This produces a 34.3% average increase in total firm service operating revenues. However, some customers will see increases in distribution rates of over 50%. Even though this is the largest increase ever requested by Washington Gas, it is being addressed without a resolution of how the gas system will interface with the district's efforts to move forward with electrification. There are significant overlaps between what PEPCO and Washington Gas are doing with respect to energy efficiency and infrastructure replacement. Also, given the district's move to electrification, the district should be targeting WG's pipe replacement activities to minimize pipe replacement costs and limit exposure to future stranded costs. For example, it is very expensive to replace cast iron mains in the district. If we are moving towards electrification, there may be segments of Washington Gas's cast iron mains that should be targeted for abandonment rather than replacement. That activity requires coordination that only this commission can provide. DC ratepayers cannot absorb the enormous increases in both gas and electric rates that are currently being considered by the commission. PEPCO's current rate increase request in formal case 1176 seeks $116 million of additional revenue in just the first year of its multi-year rate plan. That increase will cause many PEPCO GTLD customers to experience an increase of more than 50%. In addition, Washington Gas's rate increase request of $53 million also results in some commercial customers looking at proposed distribution increases of over 50%. The increases in rates being considered in these proceedings will be compounded by Washington Gas's proposed Project Pipes 3 surcharges in formal case 1175, in which Washington Gas requests approval of a 5-year plan that will cost $671.8 million. Yet, after tripling the company's DC rate base between 2011 and 2021, Washington Gas proposes to double the size of its investment again within the next 5 years. Rates for utility services in DC are already well above those in neighboring Virginia suburbs, and the proposed increase now pending before this commission are not compatible with the district's efforts to revive the commercial building sector that has been the economic engine that has driven this city for decades. As AOBA has demonstrated through the direct testimony of its witness, Bruce Oliver, the company's rate base has grown at a greatly disproportionate rate in approximately the first 163 years of the company's existence. Through 2015, WG developed a rate base of approximately $400 million. Over the last 6 years, Washington Gas's rate base, including Project Pipes, has nearly doubled to $800 million. The company now proposes more than $343 million of additional capital expense in this proceeding, and that doesn't include Washington Gas's plan to spend $671 million on its project pipes plan over the next 5 years. There is a direct conflict between affordable rates for gas service in the district for all customers and rate classes, and the rate of growth in the company's capital expenditures. This conflict should be at the core of all considerations in this case. Washington Gas is now seeking more than a 30% increase in base rates, yet the company has not justified any revenue increase. The Commission's consideration of the revenue increase request is severely impeded by a lack of transparency on affiliate transactions, Washington Gas's reliance on flawed, inappropriate, and unprecedented weather normalization data and methods, and Washington Gas's unwarranted and inappropriate proposals for purportedly climate-related surcharge mechanisms. These issues are addressed as fundamental concerns in ALBA's limited brief and will be developed more fully in ALBA's post-hearing brief. As a starting point for the Commission's consideration of Washington Gas's revenue increase request, it must be recognized there's general consensus among rating agencies, Standard & Poor's, Moody's, and Fitch, that Washington Gas's distribution utility operations represent a low-risk business. Such a low-risk business does not justify the level of equity return Washington Gas seeks in this case of 10.4%. If anything, Washington Gas's existing ROE of 9.25% overstates the return that should be associated with the company's low-risk utility operations. Yet the impact of Washington Gas's excessive equity return request is magnified by an inappropriately heavy weighting of equity within the company's proposed capital structure of 53.69%. The importance of WG's affiliate transactions in this proceeding cannot be overemphasized. A general premise in financial analysis is that more risky business operations require greater equity in their capital structures than lower risk businesses. Bondholders typically do not want to assume the risk associated with more financially leveraged operations without greater compensation for that risk in the form of much higher interest rates and more restrictive bond covenants. Yet we find that despite AltaGas's ownership of a number of substantially higher risk business ventures, AltaGas is operating with a capital structure that utilizes significantly less equity and more debt that is employed for Washington Gas's less risky regulated utility operations.
Can I ask you a question
AltaGas's
right there? I'm sorry, I just want to ask you a quick question there. You've talked now a little bit about the 53.69 capital equity, common equity structure. I believe there was in the merger agreement, there was a band in which Washington Gas is supposed to have their capital structure. Is this number within the band that was settled upon?
I don't remember, but Washington Gas is within that band.
Okay.
Okay, but I don't remember. I could furnish it, but
Yeah. That's sufficient.
they are within the band.
Okay.
Excuse me, I have a question about your affiliate transaction issue. You want to do an affiliate cost of service study. What would you need to see in that study that you can't see in the record now?
Oh, I'm so glad you asked that. Okay. Washington Gas, what we need to see are the amounts, not per books that have been adjusted, as Washington Gas has said. What we need to see is what comes before that adjustment. We need the costs that Washington Gas incurs on behalf of AltaGas's unregulated subsidiaries, and we need to know the costs and what they are. We need to see them to what has been assigned or allocated to Washington Gas. We need the cost going in, we need the cost going out, and we need to see all of those costs, because right now what we have are just some netted amounts that don't tie to Washington Gas's books. I'm looking at a confidential exhibit, so I'm not going to talk about any numbers on it. I believe it's Washington Gas R-2. And this shows netted out transactions, but we don't see the factors that they've used to allocate those transactions. We don't see how they're assigned, and we don't see any numbers in this that tie back to Washington Gas's costs. You are not seeing what's behind the scenes, what's behind the curtains. It's a lack of transparency. And I don't want to get off on a tangent and talk about burden of proof, because I'll do that more in my final brief. But there is a much higher burden of proof when you have a monopoly service and an affiliated entity. There is no presumption of reasonableness when you are looking at that. So yes, we want to see exactly what's behind the curtain in these affiliate transactions.
Just as a follow-up question, do you think that our rules on affiliate transactions needs to be revised to address some of these concerns going forward?
That's another good question that I have not thought about before standing here, but I know that we have the cost allocation manual, but that doesn't do it. I know we have the Ernst & Young limited engagement report, but that's not an audit. It's much more limited review. So I haven't looked at all of those rules in a while, so I'd like to reserve my answer for a later time. I can put an answer in our brief. I don't like to answer a question that I haven't thought about.
And sorry, just picking up on that as well. And you might not have an answer for this either, but how would this affiliate cost of study work? Would, like, in an ideal world, is your testimony here today that you would suspend this proceeding so that the study can be done, so that we would have sufficient information to then determine this rate case? Or is this a post-rate case investigation or examination that then done? Can you just kind of expound on more how the study and the process would look like?
It would look more like a cost of service study. I mean, as a lawyer, I'm not equipped to do that. There are consultants. I'm sure my consultant could know how to do that, but Washington Gas should be ordered to do that with their affiliate transactions. But I don't want to get ahead of myself in my argument, but another suggestion would be not to use the utility as a service company. Exelon does not use Pepco as a service company. Exelon has the Exelon Business Service Company, and they don't use Pepco. So another way of doing that, which I'm getting to in my argument, is to form, actually, AltaGas has a service company. It's titled AltaGas Services ASUS. It's titled with the services. That could very easily be the service company, which would eliminate a lot of the problems that I'm talking about. So that's another suggestion. Getting back to where I was, we find that AltaGas's ownership of a number of substantially higher risk business ventures. AltaGas is operating with a capital structure that utilizes significantly less equity and more debt than is employed for Washington Gas's less risky regulated utility operations. AltaGas's capital structure as of 12/31/22 had only 46.61% equity. That is essentially, it's the reverse of Washington Gas's capital structure proposal in this case of equity at 53.69%. The result of that is that AltaGas is leveraging Washington Gas's comparatively low-risk utility operations to obtain more favorable financing for its competitive enterprises. This results in unnecessarily higher costs for Washington Gas's utility operations and higher rates for district ratepayers. This subsidization through the manipulation of capital structures, however, is just the tip of the iceberg in terms of Washington Gas's overall subsidization of affiliate operations. The AltaGas corporate structure that we see today is a far cry from what it was presented in the merger proceedings, and the subsidies that result from the changes in WG's role within the AltaGas corporate structure are woven deeply into the fabric of Washington Gas's management, their finances, their operations. Importantly, the record in this proceeding does not provide the Commission the information necessary to clearly identify the impacts of affiliate transactions on Washington Gas's revenue increase request in this proceeding. I encourage the Commission to take a look at what was filed in formal case 1142, JA5, which shows the capital structure of Washington Gas and AltaGas before the merger, and then to look at the response to AOBA data request 1-2. It is confidential, so I'm not going to discuss it, and it is attached to AOBA's testimony and in the record, and it shows AltaGas's corporate structure after the merger. The company has provided its cost allocation and pricing manual. However, its CAM only outlines general allocation methodologies. There is no evidence in the record that details the actual data and calculations used by Washington Gas to determine the dollar amounts allocated or assigned to affiliates. Moreover, the limited engagement review performed by Ernst & Young does not address Washington Gas's test year's cost, and it's not an audit. The E&Y limited review presented in Exhibits P3 and P4 confidential only addresses calendar year 2020 transactions. The test year in this case is calendar year 2021. Thus, the Ernst & Young limited review cannot be relied upon to demonstrate appropriate treatment of affiliate transactions for the test year in this case. Further, the Ernst & Young limited engagement review clearly states the limits of that review and the conclusions that can be drawn from it. As stated by Ernst & Young in its report, I quote, "It does not express an opinion and it does not provide assurance that Ernst & Young became aware of all significant matters that would be disclosed in an examination." The AltaGas use of Washington Gas as a provider of services to affiliates distributed across the U.S. must not be overlooked or treated in a cursory manner. AOBA submits it's not appropriate for a regulated distribution utility to be used as a vehicle to provide services to affiliated entity. AOBA understands that a holding company may desire to seek efficiencies by providing an array of services to affiliates through a single entity. There is no evidence that the provision of such services through an entity other than Washington Gas would be incapable of achieving equal or greater efficiencies. Moreover, there is no evidence that a requirement to eliminate Washington Gas's service company role will impose any additional costs on Washington Gas or its utility ratepayers. As I said before, Exelon uses the Exelon Business Service Company. That is something that Washington Gas should do, not use the utility that way. AOBA also submits that to the extent that the formation of a separate service company within AltaGas or ASUS requires the incurrence of additional costs, those costs should be the responsibility of the holding company that has elected to use Washington Gas in a service company role. Those costs should not be the responsibility of DC ratepayers. AOBA believes this commission should be particularly troubled by the fact that Washington Gas is essentially maintaining two sets of books. One that includes affiliate transactions, but's not exposed to the commission and the parties, and a second set that witness Turanimi labels as the company's per books cost, always in quotes, which is presented for rate-making purposes, but excludes affiliate transactions. Washington Gas witness Turanimi attempts to represent that the company has merely followed FERC accounting procedures. What witness Turanimi does not disclose is that significant portions of the cost that Washington Gas attributes to affiliates under FERC accounting rules are actually the product of allocations, the details of which are also not submitted for regulatory review and public scrutiny. The merger agreement approved by this commission in formal case number 1142, order number 19396, is quite clear that the intent of the merger agreement was to have local control of Washington Gas and their utility operations. However, the record of this proceeding clearly shows that has not been the result. Rather, executives from an outside entity, Semco Energy, are assuming large portions of the responsibilities that would normally be expected of Washington Gas's senior management. The president of Semco has been assigned the role of overseeing Washington Gas's utility operations. Washington Gas has willingly entered into a contractual arrangement, a service agreement with Semco Energy, which gives broad oversight responsibilities to the president of Semco for Washington Gas's utility operations. Specifically, Washington Gas agreed to the following, quote, "The president of Semco Energy will provide oversight of the operations, customer, and business services of Washington Gas, including specialized expertise, strategy, direction, and oversight of operational areas such as capital improvements, infrastructure replacement projects, operation safety, customer service, and billings," end quote. That same service agreement also provides that the Vice President, Human Resources, Utilities, Semco Energy, will provide oversight of human resources and benefits strategy of AltaGas utility businesses, unquote. If Washington Gas is in need of such oversight, this commission can only conclude there must be significant deficiencies in the company's local senior management. If that's the case, DC ratepayers should not be paying for costs for local management that apparently is not perceived by AltaGas to have the adequate experience and expertise to handle the responsibilities that the company's senior executives would normally be expected to assume. Another fundamental element of the company's case is its reliance on unprecedented, inconsistent, and flawed weather normalization analyses. Washington Gas's normal weather study is a foundational building block for the company's entire case. Its influences flow throughout Washington Gas's development of its revenue requirements, jurisdictional and class cost allocations, and rate designs. Yet there are major problems in the development and application of Washington Gas's normal weather analysis in these proceedings. Among those problems are, first, WG's reliance on an unprecedented, unproven, arch-garch methodology for determining normal weather heating degree days. Second, departure from simple linear regression analyses to estimate normal weather gas use by rate class, and the introduction of several new variables in the company's weather normalization analysis. Third, the company's reliance on a database of historic billing determinants that has not been properly cleaned and is distorted by cancel and rebuild transactions that do not properly associate adjustments to gas use with the month in which the adjusted gas use was actually incurred. And fourth, use of inconsistent measures of normal weather heating degree days to estimate normal weather gas use by jurisdiction. Maryland and Virginia do not use the arch-garch methodology, and Washington Gas did not propose using the arch-garch methodology in either its current Maryland case or its current Virginia case. The result of the foregoing problems is Washington Gas's reliance on weather normalization analyses that are so heavily flawed that no party can reasonably be expected to correct or compensate for the entirety of the problems that Washington Gas's poorly developed and unprecedented analysis introduced in this proceeding. The arch-garch methodology that witness Rob advocates in this case is presented without substantial utility rate-making precedent, although he suggested otherwise. The record is clear. The parties did not agree to or accept that arch-garch methodology in the settlement in formal case 1162. Order number 20705 states, the settling parties agree that rates will be based on billing determinants recommended by WGL in this proceeding without any attribution to weather normalization method or normal weather study for calculating billing determinants. Washington Gas witness Rob has cited no other gas distribution utility for which his advocated arch-garch methodology is employed. In the past, Washington Gas's weather normalization regression analyses have relied on the use of simple linear regression models. Those analyses employ just two variables for each rate class: actual heating degree day measures by month and average use per customer by month. As Washington Gas witness Gibson opined in formal case 1137, I quote, "The company's weather normalization model is simple to execute. The inputs, calculation, and outputs are clearly understood while still providing a reasonable prediction of normal weather usage." In this case, the company's weather normalization regression analyses have been expanded to introduce as many as 4 additional variables for some rate classes. While simple linear regression models portray straightforward and understandable relationships between heating degree day measures and gas use, WG's addition of multiple new variables greatly complicates the interpretation of the company's regression model results. AOBA witness Bruce Oliver also documents substantial problems in the historic billing data that Washington Gas has relied upon in the development of its normal weather study regression analyses. These problems do not impact all classes in a uniform manner. Rather, the problems observed serve to significantly distort the relative levels of estimated normal weather gas use by certain rate classes, which in turn distort the company's allocation of costs, assessments of class rates of return, allocation of the requested revenue increase, and calculation of charges under Washington Gas's proposed rate designs. As AOBA has documented, there are examples within the company's historic billing determinants database in which the cancel and rebill amounts are so substantial they more than offset the entire gas use for a class for a month and give the impression that the class as a whole has negative gas use. As negative gas use for a customer, much less for an entire class, is a physical impossibility. The company's failure to properly identify such problems and properly associate adjustments to gas use with the months in which the gas consumption actually occurred greatly impedes efforts to assess the impacts of heating degree days on gas use per customer. Yet it is apparent Washington Gas made no effort to ensure the integrity of its historic usage data before running its regression analyses. This failure to ensure that usage adjustments are associated for the month in which the gas use was actually metered seriously undermines the reliability of estimates of the relationship between gas use and heating degree days by class. Washington Gas in this proceeding uses heating degree day measures based on temperature data recorded at Reagan National Airport for its District of Columbia, Maryland, and Northern Virginia service territories. However, when estimating normal weather gas use by jurisdiction, the company uses a different measure of heating degree days for the district than it uses for Maryland and Northern Virginia. For the district, Washington Gas has used 3,554 annual heating degree days to represent normal weather, yet for Maryland and Northern Virginia, the company uses 3,649 annual heating degree days to estimate normal weather gas use. This inconsistency within the company's filing results in a larger adjustment to gas use for DC than for Northern Virginia and Maryland. That distorts the cost allocated to the district in Washington Gas's jurisdictional cost of service study, and it amplifies the magnitude of Washington Gas's already large revenue increase in the district. AOBA appreciates that the regulators in Maryland and Virginia have accepted Washington Gas's use of normal weather HGD measures this commission has rejected in the past. However, that rejection of a single specific HGD averaging methodology doesn't justify the use of inconsistent measures of normal heating degree days to determine normal weather gas use by jurisdiction for purposes of the jurisdictional cost of service study. For jurisdictional allocations to yield a fair apportionment of costs across jurisdictions, normal weather heating degree days must be assessed on a comparable basis. Washington Gas has not done so in this case. Clearly, the outlier is the company's attempted use of witness Rob's arch-garch methodology, in this case for DC, without even-handedly applying that same methodology to its Maryland and Northern Virginia service territories. While AOBA is supportive of OPC's call for the Commission to mandate Washington Gas's use of a 30-year average HGDs, AOBA believes that a uniform application of the HGD determinations in the development of the terms used for jurisdictional cost allocations, I believe it's an absolute necessity. District of Columbia ratepayers will also be impacted by the company's request for a climate progress adjustment and a climate action recovery tariff. Washington Gas again seeks approval of a revenue decoupling mechanism in this proceeding, as it has done in every case since formal case 1093. The only difference in this case, the company has renamed. Okay.
Please finish your stop.
Thank you. Thank you.
Your thought.
I'm reading fast. The only difference is that in this proceeding, the company has renamed the proposed mechanism. Washington Gas now refers to its requested revenue decoupling mechanism as a CPA, climate progress adjustment, rather than an RNA. However, witness Rob openly admits that this so-called climate progress adjustment has no direct relationship to progress toward achievement of the district's climate goals. Moreover, nothing in Washington Gas's testimony explicitly links or conditions the company's billing of charges under its proposed CPA mechanism to measurable progress towards the achievement of climate goals. The CPA tariff language in this case is virtually identical to the RNA tariff language presented by witness Lawson in formal case 1162. In addition, Washington Gas's proposed CPA is almost a carbon copy of PEPCO's BSA mechanism that has continued to be fraught with problems, and which PEPCO is now seeking to convert it to an annual rate adjustment. They've taken a clause, the BSA, that has known problems that we've been discussing in several cases, and now they took that, copied it, and renamed it. Washington Gas's proposed CPA mechanism is primarily a risk mitigation strategy for the company, and it provides no benefits to district ratepayers. The only customer benefit Washington Gas attempts to argue is reduced volatility in monthly bills, yet that claim is undercut by the Commission's recognition in Order Number 18712 that month-to-month variations in the RNA add month-to-month variations to customers' bills. Witness Rob's testimony also concedes that Washington Gas's proposed CPA could add volatility in customers' monthly bills, but he attempts to portray that as theoretical. Any person who's familiar with PEPCO's BSA mechanism or WG's RNA mechanism in Maryland, they are quite well aware that the monthly rate adjustments under such mechanisms are very real and that different levels of charges must be expected each month. I was going to talk about the CART, but I'm going to say that other parties have discussed it, and we will deal with it in our post-hearing brief. Thank you, Your Honors. I'm available for questions.
Thank you, Ms. Francis.
Any questions?
Not for myself.
Was I that convincing?
Thank you.
Good morning, Commissioners.
Good morning.
Morning.
Lauren Cullum, Special Assistant Attorney General, speaking on behalf of the District of Columbia Government through the Office of the Attorney General. The district's argument today will be focused on Washington Gas Light's request for approval of a so-called Climate Action Recovery Tariff, or CART. The district views WGL's CART mechanism as a Trojan horse, one that, if accepted, would lead to increasing amounts of ratepayer money being used for risky investments on speculative technologies that are only loosely related to climate change, if at all. WGL has simply failed to prove that the CART or its proposed programs would result in any climate or ratepayer benefits that would justify pre-approved funding outside of traditional base rates. Therefore, the district respectfully requests that the PSC reject WGL's proposed CART mechanism and its programs. But before I dive into that argument, I would like to provide some information for the record information that you, the commissioners, are already aware of, but that the district feels are important to highlight for this matter. Starting with why the district has set forth significant climate change policies. As you've noticed last week, we had record high temperatures in the district. We are also, believe it or not, in the midst of a drought. And as I'm sure you've seen on the news, the countless wildfires, hurricanes, flooding, and other weather events that are taking place. These events will worsen and increase in severity as global temperatures rise. This is why the district has set aggressive goals that are focused on reducing greenhouse gas emissions and encouraging decarbonization to help address climate change. For instance, in 2018, the district's Department of Energy and Environment released its Clean Energy DC plan that set forth a roadmap for achieving the district's climate goals, including GHG reduction targets. Since the plan was issued, the DC Council has passed numerous pieces of climate and clean energy legislation, including the Climate Commitment Act, which set a mandatory target to achieve carbon neutrality by 2045. The district's climate policies and laws are primarily focused on 3 sectors. Buildings. We have many building electrification policies. For instance, all new buildings must be constructed to meet net zero energy standards starting in 2027. Transportation. We have many transportation electrification policies that are supporting a transition to electric vehicles. And our energy supply sector. For instance, the district's renewable portfolio standard laws now require 100% of retail electricity sales in the district to come from renewable energy by 2032. These goals can only be achieved by a fundamental rethink of the role of fossil gas in our future. However, WGL has consistently failed to align itself with the district's climate goals. As we've seen in the company's actions, plans, and filings in this proceeding and others, the company is not appropriately planning for the district's decarbonized future, which will see a reduction in demand for fossil gas and the gas pipelines. WGL's business as usual, yes.
Let me ask you a brief question. You've mentioned the district's long-term climate goals and a number of policies that the district has adopted pursuant to those goals. Additionally, and maybe you're going to get there in your argument, the district operates a number of energy efficiency and electrification programs to help move the district forward in the attainment of those goals, does it not?
Correct.
Is it your view that those programs by themselves will be sufficient for the city to attain its long-term climate goals?
I think that as we progress and as climate change worsens, we're going to have to make adjustments year after year, and there are ways that those energy efficiency programs may not be sufficient anymore. And I think one thing that we just need to focus on in the district and that the agencies need to focus on is right now working towards those decarbonization goals that we have right now, because those are difficult to achieve even in and of themselves.
Right. So pursuant to the district's clean energy omnibus legislation adopted back in 2018, the utilities, PEPCO and Washington Gas, will now be permitted to operate efficiency programs to support what the district is already doing. Is that correct? But they have to review those programs with the district.
Right.
Were the programs that are being proposed by Washington Gas reviewed by the district?
Which programs?
Specifically these in the cart.
The ones that have been presented in this case? I mean, I think that that's why we're talking about this right now. And I mean, excuse me if I'm incorrect, I'm just kind of new to this matter, but my understanding is that WGL has presented all of the information on these programs, and that in the district's view, they have not satisfied a showing of a connection to any type of climate action or climate commitment that the district already has in place, or that, you know, that would align itself with the district's goals.
Okay.
And as I was saying, that the district...
Just more specifically, I guess, and maybe you're not in a position to answer this. Should these programs have been reviewed by the Sustainable Energy Utility Advisory Board? Or
I'm
were
sorry.
they?
Yeah, I'm not in a position to provide an answer at this time, but I can get
would
back to
fall
you and
outside
let
of
you
it.
know.
Okay, all right.
One of the programs, WGL's programs, that I want to highlight that shows that the company is setting itself up for problems in the future, and those problems may have detrimental impacts on ratepayers, is the Project Pipes program. The program is replacing old leak-prone pipes, but it's also extending the lifetime of a pipe system by 50 or more years, even though the district has a carbon neutrality goal to meet in 22 years. And programs like this create future stranded asset risks, as many of these gas assets may not have a role in the district's decarbonized future. And
So let me just ask you a practical question there. If the pipe is leaky and old, should Washington Gas not replace it?
I think for safety concerns, the pipes should be replaced. But the problem with the program is that they're not taking into consideration the fact that some of these pipes in the district may no longer have a need in the future. So there needs to be more of a targeted approach in replacing these pipes so that you're addressing safety concerns at this time. But then you also need to be planning for the future when some of these pipelines should be phased out or retired.
So you would suggest a process in which, in theory, a pipe that's leaking is either, in some cases, repaired and other cases decommissioned. Is that what your suggestion?
Mm-hmm. Nothing has changed in WGL's approach over the years, and nothing in the present matter indicates a change, which brings me to the crux of the district's argument today, in that the PSC should reject the proposed CART and its funded programs. Because first, like WGL's other actions and programs, the CART mechanism also fails to account for the district's climate policies. And second, the CART is an inappropriate shift of risk from WGL's shareholders to its ratepayers, and certainly doesn't justify pre-approved funding. First, the CART includes a portfolio of actions that are contrary to the district's climate goals, and for which no emission reductions have been estimated. WGL has not compared the GHG reduction potential or environmental benefits of its CART-funded programs to any alternative programs, such as ones that focus on transportation electrification. For example, under its proposed fleet compressed natural gas or CNG infrastructure program, the company wants to enhance its CNG fueling infrastructure and procure renewable natural gas or RNG to accommodate CNG vehicles. This goes directly against the district's plans to encourage switching to electric vehicles, not vehicles using RNG. In the Clean Energy DC plan, there is a high priority placed on increased electric vehicle adoption and on programs and policies that support this transition to electric vehicles, including EV transit buses. We also have the Transportation Electrification Roadmap, which sets forth strategies and recommendations to help the district achieve zero-emission vehicles by 2045. Instead of looking into the feasibility and cost-effectiveness of electric vehicles, which we know will help reduce climate emissions, reduce local air pollution, and help achieve the district's climate goals, WGL focuses on vehicles reliant on CNG and RNG. And I'd like to note that emission rates from RNG are still very uncertain and vary widely based on a number of factors. And in some instances, depending on where it comes from, may have a carbon intensity in line with fossil gas, so there would be no emission reductions in that situation. In addition, many of the CART proposed investments are speculative, unproven, and could be extremely costly. For example, WGL's hydrogen fuel cell zero emissions mobility pilot is expected to cost approximately $4 million. Yet the company has provided no justification for the cost effectiveness of the proposed vehicles and associated infrastructure, especially related to any alternatives, nor has it provided any information about the operational costs, which could be high. And it's proposing to purchase vehicles that are not yet commercially available, while also failing to consider competing electric vehicles which are commercially available and which we know will result in climate benefits. WGL did not commit to how the hydrogen will be produced either, and which, if it's produced using methane, could result in more climate harm. And I'd like to talk about hydrogen for a minute because it comes up in a number of WGL's proposals and proposed programs. If hydrogen is produced using methane, it could result, like, as I said, in more climate harm, more GHG emissions, since methane is a very potent greenhouse gas. If it's produced via electrolysis using renewable energy, yes, it could be carbon neutral, but it's extremely expensive, highly energy intensive, And if there's a leak, it would undo any climate benefits because hydrogen is a more potent greenhouse gas than carbon dioxide. Also, there are limitations on blending hydrogen into the current pipeline system. Right now, the current pipeline system can only handle a small percentage of hydrogen blended into it, which would not amount to many emission reductions in that scenario. Otherwise, the entire system and end-use equipment would have to be replaced, which would be extremely costly, and we're still unsure about what the emission reductions would be in that situation, especially if there's a leak. Moreover, WGL has failed to articulate any clear standards for what types of programs would qualify for CART beyond the vague claim of, quote, to further the achievement of the district's climate goals. The PSC should reject the CART because approving a vague standard such as that could open the door to future proposals that are similarly unsupportive, speculative as to the benefits, and could inadvertently undermine the district's climate commitments. The second point I'd like to make today is that the CART mechanism inappropriately shifts risks to ratepayers. Considering that these programs may not result in any climate benefits and could result in future higher costs, who should be responsible for dealing with the risks posed by these programs if things don't go right? With the CART mechanism, WGL is seeking pre-approval for funding programs that conflict with the district's climate commitments. This puts the risk of these investments on the ratepayers if the programs end up being a bad investment or not prudent.
If I could interrupt you for a second before I lose the thought. The government had an objection to fuel cells for trucks, like Class A trucks. These would be 18-wheelers, I guess. Those trucks do come into the city, and you said in your brief, I'm going on my recollection now, that would primarily apply to long-distance hauling.
Right.
So I imagine something in excess of 180, 200 miles, something like that. And that seemingly the implication was that has no benefit to the district. But if you think of yourself and I'm just throwing that out there, as one large climate ecosystem, and you're going to have California trying to produce trucks that go across country, why would the district want to be the destination of diesel vehicles rather than hydrogen and fuel cell vehicles? And I'm assuming, and because the brief didn't say, I'm assuming that the electrification of an 18-wheel truck has problems, that the batteries are so big and heavy that it takes up cargo space, and that you have to charge these for considerable periods of time to go from one side of the country to the other. But if you think of it in terms of, and I'm not disagreeing with anything that you said, but you think in terms of it as you're trying to encourage non-gas vehicles, and the only option for this 18-wheel truck, we can't keep them out of the city. They bring food and other things. I'm trying to not discourage the company from exploring options that may actually be beneficial, even though the truck's whole hauling is not inside the district, obviously not going to do 180 miles inside the district. But I'm trying to get an idea of what the thought process is here. I understand we have our own company and we have our own concerns, but we don't have our own climate. It's one we share with everyone else.
Right.
And so to some extent, if they are trying to clean up part of it, doesn't that help? And with regard to the cost, I don't know why it costs $4 million. I do know an 18-wheel truck probably costs, I don't know, like $160,000, $170,000 or something. If you're talking about a hydrogen fuel cell truck, that might cost twice that. A battery-operated truck, assuming that they could be feasible, probably costs more than that. So if you're trying to encourage people to use these technologies, and I'm just going, if I had to invest in a $300,000 truck or more, I would want to know that I had destinations that I could go to. So I'm trying to get an idea of shouldn't we be trying to attract the low emissions vehicles rather than the diesel trucks? I know that wasn't what you were suggesting necessarily, but I just wanted to throw that out there.
And I do recognize that moving in the direction of away from diesel and using things that have lower emission rates is a positive direction. I think for the purposes of this program specifically, aside from, in addition to everything that we put forward in our brief and what I mentioned about WGL is just not providing enough information at this point. for this particular program that would justify pre-approval for the program. I think that if we had seen more information, again, like, this is just not the correct mechanism to use to fund this type of investment, especially considering the lack of information we've gotten from WGL. I don't think by rejecting this program or any of these programs comes down on the PSC doing something that's, showing that they're not supportive. I think that the PSC is in its right mind to have that oversight over the utility, and the utility is not doing its job to show that its investment in this is just and reasonable and would justify a pre-approved funding in this particular program. I didn't exactly answer your question right on the nose, but I feel like, in terms of the program, in what I'm focusing on today, that's...
I think you clarified it. Okay. I wanted to throw that out there for general thought, that there are some issues with regard to that. Your comment about blending hydrogen, I don't know what the company's plan for doing that is, but to my knowledge, you probably can't do it over 20% anyway.
Right.
And that you have to have you have to have appliances that can burn it.
Right.
And so if you don't sell hydrogen-friendly appliances, it wouldn't do any good to try and blend gas, assuming that you can do it. I don't even know that you can do it that way. I know people are talking about it. Right. But I think it's a technology worth exploring, and if possible, if the gas lines, if we're talking about transitions, and if the gas lines can be repurposed as opposed to abandoned, that would be preferable to me.
Correct, but who should bear the risk of
I'm
that
not debating that. I get
I
you on
think
that.
we're on the same page. I think it's just, if you're going to invest in a program or a project that we don't know exactly what it looks like at the end, and it could be extremely costly, that shouldn't be put on the ratepayers. That should be put on the company and its shareholders.
I understood you. I just want to make sure that we don't take off the table inadvertently things that should actually be on the table. Maybe not the way it was put on the table initially, but it's still worth thinking about. That's all I was trying to say.
Yes, and as climate change worsens, and as I mentioned earlier, we're going to have to think of new innovative ways to address the climate impacts as well. So, having not necessarily hydrogen, but having more conversations about different types of technologies and programs is an important one. But I think that if you're going to be putting the risk and the burden on ratepayers, then that's inappropriate, at least in this situation. And in addition, and following with what I was saying before, in that these risks, the risks of these investments, on putting them on the ratepayers, the ratepayers should not be on the hook for a utility, for the risks a utility creates for itself by failing to respond to policy changes. And because under CART, this program, this mechanism can be used for any action that's vaguely linked to climate change, this is opening the door for WGL to have ratepayers covering a wide range of actions without any assurances that they are more cost-effective or could have any impact on emission reductions. In fact, WGL has failed to show that these programs are just, reasonable, or would result in any benefits to ratepayers that would justify pre-approved funding. Under certain programs, it makes no sense that the ratepayers should fund them based on the benefits it would bring solely to WGL. For instance, the direct emissions measurement program, which would fund a study to understand GHG emissions from the gas industry as a whole. This is data that is obviously important to shareholders for future business directions, but WGL has failed to justify how this would benefit customers at all. In sum, the CART mechanism is a method of diluting the PSC's oversight in terms of how WGL is spending its money. The company should not be permitted to avoid its responsibility of establishing reasonableness for recovering its investments. If the company wants to invest in these programs, it should spend shareholder funds up front. If WGL believes that any of these programs deliver a net benefit, a net value to district ratepayers, it could attempt to justify the net cost and the benefit in the next rate case and ask for recovery of the cost at that time. For all of the reasons I've mentioned today, the district urges the PSC to reject WGL's CART and its proposed mechanism and any surcharge, and its proposed programs, and any surcharge funding for the programs proposed to be included in the CART. Thank you.
I could just say to clarify, when I talk about hydrogen, I'm talking about green hydrogen, not gray and blue.
Right, right. And I think that was another issue that we had, was that WGL refers to it in terms of clean hydrogen, but doesn't clarify what that even means. And yes, green hydrogen even can be, as you were mentioning, replacing a lot of equipment, replacing a lot of pipes, and can be extremely costly. It can also be highly energy intensive, so that it's using more energy to even produce the hydrogen than just using electricity directly. Any other questions? Thank you.
Okay, thank you. Yeah, no, Sierra Club.
Chairman Thompson, Commissioners Beverly and Trabue, thank you for the opportunity for Sierra Club to present today. My name is Tim Oberlet, and I'm with Earth Justice, representing Sierra Club in this matter. I want to make 4 key points that are of importance to Sierra Club in this case. First, that determinations on WGL's climate proposals will result in unjust and unreasonable rates without the cost-benefit framework pending in GD 2019-04M being determined, or determinations on the climate business plan, from which a lot of the climate proposals are based, in formal case 1167 is resolved. Second, as mentioned by many parties today, WGL's CART and underlying proposals are inconsistent with DC law and policy, and otherwise unsupported in this record to provide benefits to ratepayers. Third, WGL does not meet its burden on the CPA or to make a differentiation as how it's different from the RNA, which has been proposed and rejected for several years. Fourth, WGL's alternative combustion fuels are also antithetical to the district's goals and ill-suited for our energy ecosystem and should thus be rejected. WGL is seeking an unprecedented and exorbitant $53 million rate increase, as well as approval of so-called climate initiatives and rate mechanisms to support these plans. These programs, as well as the Climate Action Recovery Tariff and Climate Progress Adjustment, are unsupported in the record, unjust, unreasonable, and do little to reduce emissions from the continued use of methane gas. Further, they are in complete derogation of the district's climate mandates, the realities of the climate crisis, and the imperative to reduce DC's use of methane gas and alternative combustion fuels while transitioning to an electrified economy. As noted by Counsel for District Government, the district's legal mandates and policy goals all contemplate a speedy movement away from methane and combustible methane alternatives in order to achieve deep decarbonization targets necessary to fight the climate crisis. These policies overwhelmingly favor these steep reductions achieved specifically through electrification, and the continued combustion of gas simply does not make sense in light of these goals. As pointed out in Sierra Club's filing in this case and in formal case 1167, these legislative mandates are predicated on findings that gas must be phased out and in favor of electric alternatives which are more efficient, cleaner than the gas that is available today. The writing is on the wall. The future of DC is electric, and the various district policies are eliminating gas end uses and providing pathways and incentives for existing customers to transition away from methane gas. In contrast, the majority of WGL's so-called climate initiatives propose measures that, at best, would result in minuscule reductions in emissions and represent a business-as-usual approach of delivering methane as set forth in the company's 2020 climate business plan. These measures are being proposed in the context of WGL's failure to acknowledge that gas utilities will necessarily experience significant reductions in gas volumes sales over the next 20 to 30 years. Indeed, WGL's climate business plan, which is the source of the climate proposals in this case, is premised on faulty assumptions of substantial volumes of methane over the next 30 years, with only limited attempts to offset through energy efficiency programs and purported offsets from alternative combustion fuels. By contrast, in a study prepared by E3 in Maryland for BG&E, the company itself acknowledged that it expects reductions in gas sales ranging from 54 to 70% in 2045 relative to 2020 levels, including reductions in the use of those alternative combustion fuels being proposed by WGL here. WGL's programs, projections, and plans are simply divorced from reality and should be rejected by this commission. As has been discussed today, it is exceedingly difficult to assess WGL's proffered emissions reductions. Indeed, WGL's failed to demonstrate meaningful emissions reductions from any of these operations or programs that would justify ratepayer dollars for the initiatives. For example, WGL's rebranding of its Project Pipes activities as a climate initiative is in this case and in the climate business plan, and it lacks credibility and our transparent attempts to greenwash its advanced pipeline replacement program. In the March 2020 Climate Business Plan, WGL promoted Project Pipes as driving 22,000 metric tons of CO2 emission equivalent reductions from 2014 to 2021. 2 years later, in March of last year, and only when pressed in discovery by Sierra Club, the company downgraded these estimates to 18,325 metric tons of the same period. Despite that downgrade, Witness Adams again represented to this commission that Project Pipes was responsible for those 22,000 emission reductions when it filed this application on April 4th of 2022. 2 months later, in June of last year, WGL filed correction to its testimony, but in that further reduced the emissions reductions to 12,000 metric tons, nearly half of what was initially promoted in the climate business plan 3 years ago. Washington Gas, simply put, Washington Gas cannot get its emissions story straight, which calls into question any of WGL's ability to accurately measure, track, and represent these emissions reductions associated with its operations and its programs. As to Project Pipes, it seems less about safety and reliability than a transparent effort to lock in gas assets prior to the district moving to adopt electric end uses in light of the legislative mandates discussed earlier. In sum, WGL's proposals in this case in the climate business plan wholly disregard the international, national, and district level response to the climate crisis, all of which are unified on the idea that decarbonization can only be achieved through moving away from methane and alternative combustion fuels. As to GD 2019 and formal case 1167, I think in answering a question from Commissioner Trabue earlier as to the correct forum for these climate proposals, any action on climate initiatives in this matter are premature without the cost-benefit framework is to be established in GD 2019-04M, and without determinations on these utility initiatives and the climate business plan in formal case 1167. WGL knows that these proceedings have been stalled and knows that they would not end favorably for its continued business as usual approach. WGL is now seeking to get advanced approval of its so-called climate programs and funding mechanisms in this case, even though the framework to appropriately weigh them has not been resolved in GD 2019-04N. Approving these climate proposals here would result in unjust and unreasonable rates, and the determination would be arbitrary and capricious without the appropriate framework coming from that matter. The Commission has yet to determine how it will weigh the appropriateness of utility proposals, such as those filed by WGL in this docket. In GD 2019-04M, which Sierra Club contends is necessary for this Commission to resolve before proceeding, the Commission oversaw a substantial working group process where stakeholders, including Sierra Club, discussed and made recommendations for the Commission's analytical tool to use when reviewing utility proposals in light of the district's climate commitments. Following many months of working groups, on November 16, 2021, Commission staff filed an over 300-page report of the Clean Energy Act Implementation Working Group, outlining the consensus and non-consensus positions of the stakeholders. The Commission has yet to make a determination on what framework it will adopt in order to view climate proposals by these utilities. Without the benefit of this framework, which would establish inputs, a cost-benefit analysis tool, reporting requirements, performance, the utility filings to date in this proceeding could only anticipate what the Commission could possibly need for an appropriate review. Accordingly, it is premature for the Commission to make determinations on these climate initiatives and supportive rate mechanisms as they stand today.
Can I ask you a follow-up question on that? Recognizing that, of course, the framework has not been finalized by the commissioners. Let's say there were a number of programs that Washington Gas proposed through 1167 and it went through the analytical framework. Would there then be the opportunity for them to have something like a cart to recover those funds? Or what are your thoughts on that?
If there was the ability for proper vetting and a full review of those programs with the appropriate safeguards in place as to what their full costs would be, what any potential benefits, there would be an appropriate level of recovery for any utility wanting to make a proposal that passed through what would be a rigorous process to make sure it met the district's goals. I don't know if it would be specifically in 1167 as it stands currently, but in that docket, the commission has said that that docket is the clearinghouse for a lot of these proposals and would allow for safeguards to review those, such as incorporating the framework, incorporating the district goals, and also perhaps having hearings and discovery, all of the traditional safeguards of a litigated proceeding to judge those matters. WGL's so-called climate initiatives are also improperly proposed here since they're all founded on its climate business plan, pending determination in that docket, Mr. Chairman. In that case, various interveners, including Sierra Club, have shown that WGL's programs are completely out of sync with the district's climate policies and mandates, as well as being wholly inconsistent with the necessity to move away from fossil gas. In the initiating order of formal case number 1167, the commission stated that procedure through which it would review utilities' proffered climate proposals and elaborate on how the commission envisioned considering those proposals. The commission was quite specific that in formal case 1167 would be the clearinghouse, as I mentioned, for any of these climate initiatives. And in the initiating order said, it will then investigate the proposal, permit comments, and if warranted, hearings to evaluate and make determinations on the given proposal. Commission provided no carve-out for WGL to file its proposals in the instant rate case application or to jump ahead of determinations in that case or GD 2019-04M. Instead, the commission's intent was to engage in comprehensive planning of the district's climate commitments, and that docket's initiating order went further. It said it would include the development of a comprehensive plan for how utility or energy companies can help achieve the district's goals. However, and in the opposition, the many parties filed motions to clarify the commission's intent with that order. In opposition, AltaGas and WGL asserted that the commission declined to order AltaGas and WGL to file a comprehensive plan, reserving that decision for the future. However, the commission clearly rejected that reasoning, and the commission stated its intent to hire an independent consultant to develop a comprehensive plan on how the commission's regulated utilities can achieve the district's climate goals, and that the independent consultant would be beneficial in reviewing the climate business plan, the climate change commitments, and other stakeholder filings, as well as the plans from other jurisdictions to determine how the commission could determine the district's climate goals by utilities that it regulates. It is imperative that the commission not entertain premature and piecemeal requests regarding the appropriateness or prudency of proposals claiming to meet the district's climate commitments. WGL's proposals and rate mechanisms in this case are just that and should thus be rejected. I want to discuss a little bit about the fuel sources that are raised in WGL's application, which is replete with false claims of these solutions as promises as methane alternatives that are unsupported by the record. First, I want to discuss certified gas. Washington Gas's plans for so-called certified gas or responsibly sourced gas are incompatible with the district's climate goals. It is important for the commission to understand that certified gas is a process that purports to verify best practices connected with the extraction of fracked methane gas at the gas well. This is done by third parties retained by the gas industry and the utilities without standardized methodologies. And indeed, there are no established standards for this certification process, and the Federal Department of Energy announced plans last July to halt endorsement of any given standard regarding certified gas. Sierra Club witness Dr. Grubert highlights this lack of standardization and points out that the overall life cycle emissions of different types of certified gas vary, are still dominated by end-use combustion, and even if WGL were to provide some level of rigor to the data, analysis, and proposals for certified gas, which it does not in this case, any emissions reduction from certified gas would be de minimis, rendering CG usage unjustifiable as a climate action and incompatible with the district's goals. Washington Gas's efforts to promote certified gas as a climate measure are nothing more than an extraordinary attempt, again, at greenwashing, where the gas industry is taking an environmentally devastating practice, hydraulic fracturing for methane, having an unregulated third party certify that the fracking was done in a way that allegedly minimized methane leaks, and then rebranding that fracked gas as a climate solution, as WGL does throughout the climate business plan and in this case. These flaws in WGL's bid for certified gas notwithstanding, it appears that ratepayers in DC are already funding this program. WGL has been allowed to obtain 2 contracts for the inclusion of certified gas and recovering costs associated with those purchases through an additional surcharge on ratepayers' bills called the gas procurement charge. It is widely acknowledged that certified gas is procured at an additional cost and sold at a premium to ratepayers. As pointed out by witnesses in this case, ratepayers are not receiving tangible benefits from this premium surcharge. And when asked in discovery whether there was additional cost associated with deliveries of certified gas, WGL flatly rejected the concept and provided no analysis or data to support its claims. The Commission should soundly reject WGL's claims regarding certified gas and halt WGL from procuring costly, ineffective fracked methane funded by ratepayers. I also want to address hydrogen, as has been addressed in this case so far. Witness Adams extols the company's unsupported promises of hydrogen for use in a variety of end uses and pilots, but those claims are wholly unsupported in the record and should be rejected in this case. In addition to the vague hydrogen mobility proposals, Witness Adams alludes to the climate business plan for blending hydrogen in a future gas supply, promotes hydrogen as a storage capability, and references clean hydrogen, which, as was noted, has no clear definition and no tethering to the established processes of the rainbow of different hydrogen that exists. However, as described by Dr. Grubert, hydrogen is not a good alternative to electricity where electrification is possible because it takes much more electricity to make hydrogen than to use electricity directly. Hydrogen is also unsuitable as a substitute for methane, since blending at ratios even as high as 20% by volume would result in avoidance of only about 7% of the original natural gas CO2 emissions, even if the hydrogen is fully GHG-free and is green hydrogen from renewable sources. Instead, a growing consensus of research has shown, given its inefficiencies, costs, and emissions limitations in comparison to readily available electrification alternatives, hydrogen should be reserved for hard-to-electrify scenarios. The vast majority of end uses for buildings and transportation have existing, efficient, and clean electrification applications, and widespread use of hydrogen is not a fit for DC's energy ecosystem. Witness Yardley similarly offers no support for the company's inflated enthusiasm for hydrogen's potential. Witness Yardley vaguely claims that, quote, hydrogen is also receiving increased attention with demonstration projects around the US and globally, and given these developments, it is entirely appropriate for Washington Gas to take similar actions. However, Yardley provides no data, no analysis, or evidence in this case for this utility to make hydrogen an appropriate end use case. Dr. Grubert accurately points out that Washington Gas has not demonstrated hydrogen as an effective use that are common amongst the customer base, which is readily available in terms of electrification alternatives. DC has few hard-to-electrify scenarios. Indeed, WGL admitted in discovery that it's completed no important analyses about emissions or about issues like impact on hydrogen on user equipment or for its specific end use cases that could be tailored to fit the district's needs. Accordingly, the Commission should reject WGL's proposals for ratepayer funding and hydrogen pilots and otherwise disregard Washington Gas's silver bullet approach on hydrogen. Now, a number of parties have spoken today about the CART and the CPA, so I'll limit my comments on those. Specifically, as to the CART, OPC has pointed out that this is a non-traditional mechanism that has a high burden in order to be met for approval, which Washington Gas has not met in this case. Regardless, WGL has not met this burden to show its spending is just, reasonable, or in the public interest on any of these programs. WGL's CART is an unneeded mechanism that allows WGL to fast-track untested projects with uncapped and escalating costs. This is particularly egregious, which, as has been pointed out in this case and in formal case 1167, that these proposed projects from the Climate Business Plan are fundamentally incompatible with DC's law and policies. The CART should be rejected because the underlying programs that it's meant to fund are not beneficial to ratepayers. The CART impermissibly shifts the burden from WGL to its ratepayers to fund WGL's preference for a business-as-usual approach to continue delivery of gas and institute false climate solutions. This spending does nothing to address the real problem of massive emissions stemming from the delivery and use of WGL's methane gas products. Sierra Club also agrees with the other parties' contentions regarding the climate progress adjustment that should be rejected, as was raised by many witnesses from OPC and AOBA. This decoupling mechanism is not tangibly different from the revenue normalization adjustment that has been rejected soundly many times by this commission. And WGL otherwise provides no support for its claims that this is needed in light of existing energy efficiency measures and also in light of an already declining sale of gas volumes. OPC witness Dismukes accurately points out that the commission, in rejecting prior iterations of the CPA under its RNA moniker, noted that declines in gas sales were already occurring without such a mechanism and without the EE proposals. OPC witness Dismukes also points out that the commission has previously doubted the commission's argument that decreasing gas sales would disincentivize WGL's provision of energy efficiency programs because the DC already has the DCSEU and various other electrification programs. For those reasons, the commission should reject the CPA as it does not fulfill any of the stated objectives that WGL purports. In sum, we are all sitting at the crossroads of the climate crisis, but there is a consensus on what must be done to fight off its worst effects. We must be focused on swiftly moving away from methane and toward an electrified future. Now is not the time to continue business as usual, and is certainly not the time to give credibility to WGL's false climate initiatives that do nothing to meaningfully reduce the district's emissions. They will only result in wasted spending funded by already overburdened ratepayers. The commission has the authority and the ability to reject WGL's climate proposals in this case and to regulate the gas utility in a manner that achieves the district's climate goals. With the authority and the ability comes an obligation to ensure that utility rates are just, reasonable, and non-discriminatory. In the context regarding Washington Gas, Sierra Club submits that the commission must reject the company's climate initiatives, reject the CART, reject the CPA, and not give credit to the company's misleading, self-serving claims that only serve its shareholders and not ratepayers and do little to advance the district's climate goals. Thank you.
Just one question.
Right on back.
This is with regard to project pipes, and it may not be a question that you can answer directly, but I'm throwing it out there. Our project pipes program is directed toward high-risk pipes that present the most likely potential for an explosion. Maybe there is a need to have a companion analysis that talks about not just pipeline safety, but climate safety. For instance, I don't know, given a leak, a specific leak, when you talk about what its potential is as a high-risk leak, I don't know if there's also low-risk super emitters that contribute more to a climate problem than another kind of leak. So is that something you think we should look at or have you thought about that?
Starting at the end, first, Commissioner Beverly, there is currently not that parameter in the program to find any of these low-grade super emitters or even the framework for looking at this as a climate problem. Washington Gas is very quick to label project pipes as a climate initiative, but as I pointed out, the emissions reductions are inconsistent and low. In terms of the program continuing to operate, it's been suggested in other dockets, including the pending Project Pipes 3 proposal, that targeted replacements that could be done at a fraction of the cost can address some of the worst pipe. It has been acknowledged by the fossil fuel industry that replacement is a moneymaker for utilities, which is why they are routinely buying gas utilities and case in point, Dominion offloading much of its gas utility holdings to Enbridge. I think that a program, and this will be litigated in Project Pipes 3, but reframing project pipes and the analysis of it and what does safety mean must include climate safety. If you're looking at health and safety, climate health, the impacts on individual ratepayers' health directly attributed to emissions from the use of gas that goes through these pipes that are being replaced at a premium should be addressed in a cost benefit of this program and of any of the utility programs, as was suggested in GD 2019-04M. I think measures like that can address how we look at project pipes and address more targeted and specific measures to get the leakiest and most dangerous pipes from an explosion safety perspective, but also reframe the program or some other program at addressing pipe repair that takes into account the health and safety, the climate health and climate safety aspects of those replacements or repairs.
Now, are you currently participating in a working group that would allow you to interject those thoughts?
To the extent that there is a working group that exists for the Sierra Club to inject those thoughts, we would love to be a part of it. It is something that we stressed in GD 2019-04M. It is something that has been litigated before the commission in the various project pipes dockets, but if there were to be, it's something that we put forward in the stakeholder process as it's viewed as such in 1167, put forward those arguments. I think that it is on our radar. I think it's on the intervener's radar, and hopefully it's on the commission's radar as an important issue of how to reframe repairs and replacements of pipe in the district.
That was only in GD 2019.
I believe, yes, a lot of those issues in terms of reframing the health costs, avoided healthcare costs of continued gas investments, that was in GD 2019-04M. And again, if those were to move forward and be applied to the range of utility proposals like project pipes, that would then be considered in that case. Currently, it is not.
Thank you.
Thank you.
And now we'll have Washington Gas come back up for the rebuttal.
Thank you. I'd just like to touch on a few points that were raised by the other parties. With regard to the financial harm that the company is experiencing, I think the record fully supports the need for rate relief and speaks for itself, so I won't elaborate on those issues. With regard to the climate progress adjustment, the climate progress adjustment should be approved to ensure fair regulatory treatment for Washington Gas and to support implementation of DC's decarbonization goals. While there may be some variation in bills as a result of climate progress adjustment, the cap proposed by Washington Gas will help to mitigate volatility in month-to-month bills. With regard to OPC's comments on reducing the ROE due to alleged poor performance of project pipes, the Commission has thoroughly reviewed the project pipes program and other dockets and has not determined, per se, that the pipes program has been mismanaged. OPC failed to acknowledge the positive observations in the Liberty Audit Report of the pipes program, and they failed to acknowledge the fact that there are a number of factors outside of Washington Gas's control that have caused an increase in the cost of that program. With regard to affiliate issues, the company has fully addressed affiliate transactions in the testimony of company witnesses Tornimi, Nufrio, and Jerovic. And despite AOBA's criticisms, Washington Gas has fully complied with the Commission's regulations governing affiliate transactions. Washington Gas has shown that there are advantages to customers in using shared services, and there is no evidence of any manipulation of the capital structure, as AOBA has suggested. Just to refresh, with regard to AOBA's concerns about having two sets of books, the company's witness, Tornimi, has stated that Washington Gas has one set of books that includes all of its transactions. Washington Gas maintains its books using FERC's Uniform System of Accounts, or USOA. The cost of service is set using FERC USOA, and every adjustment in this case has been tied to an appropriate FERC account. The per book information has not been adjusted for any affiliated transactions because no adjustment is required. Affiliate transactions are kept separate from Washington Gas's transactions per FERC's regulations. There is no commingling of transaction or activities. The cost of service does not need to be adjusted to remove any affiliate charges because they are either not on Washington Gas's books or are reflected in the books in the balance sheet accounts. and excluded from the development of the revenue requirement. With regard to AOBA's comments on terminating Washington Gas's role as a service company, as I said before, Washington Gas has complied with the Commission's regulations governing affiliate transaction and files its CAM, cost allocation manuals, with the Commission for review and approval. AOBA has presented no evidence to suggest that any such transactions are improper or imprudent. Corporate use of shared services for certain important functions is not only common, as testimony has been presented, but is critical to the efficient and effective management of a business. It is efficient since certain of these shared services are duplicative across various commonly owned affiliated entities. There are economies of scale and scope that can be realized with shared services among affiliates, which can result in lower operating costs and lower rates for customers. The shared services arrangements that the company employed during the test year have been utilized for Washington Gas for decades. Post-merger, new and different affiliates have been involved, but the types of services that have been shared has not changed. Forming a shared services company would require significant time and financial resources on a one-time and on an ongoing basis. These additional costs would not benefit customers or bring any additional cost savings that are already afforded customers. AOBA has provided no analysis that imposing the cost burden on customers of creating a new service company would be justified by any future benefits. Thank you.
I did have one thing to say, and I thank everybody for participating in this. Yeah, I know it's a new format for us, and so I encourage people to share with us what you think worked and didn't work so that we can better refine this if this is going to be something we continue to do going forward. Just because it works for me, I kind of like it. Just because it works for me doesn't mean that it works for everybody else. So I'd like to get the feedback when you have an opportunity to provide it.
Thank you.
So I believe we had 2 bench requests during the hearing, one from Commissioner Beverly and one from myself. We would like those within the next 5 business days, submitted through normal course. And if nothing further, that adjourns today's hearing. Thank you, everybody, for attending, and thank you.